did you want to set this over, or Jennifer Gledhill, Gledhill?
She was added to the calendar. Her counsel is present here. So.
Oh, perfect. Okay.
Is she available, or?
She will be.
She's right here.
In Charlie Pod. All right. Good morning, ma'am. Is your name Jennifer Gledhill?
Yes, it is.
And is your birth date February 4th, 1983?
Yes, it is.
This is case 241912513. Miss Gledhill, have you seen a copy of the charges that you're facing?
Yes, I have.
And Your Honor, we'd waive any further.
Oh, I'm sorry, Mr.
of the
Davis.
information.
I didn't see him. So, ma'am, your attorney's present. Can you turn on the lectern cam so we can see Mr. Davis? There we go. All right, ma'am, your attorney is present here in the courtroom. So he's going to go over the specifics of the charges with you, ma'am, and answer any of your questions. And there are some issues we need to discuss. Number one is that the state is requesting a pretrial protective order. The protected parties, in this case, there are 3 protected parties, ma'am. So I'm going to read their names and then ask if you know them. Do you know all 3 of those individuals, ma'am?
Yes.
And Ms. Argyle, can I ask the state, what's the basis for the protective order? They're not listed, those individuals are not listed as alleged victims.
Children of the victim and the defendant, and there is some concern about obstruction that has been alleged to have already occurred and involvement with the children specifically. They will be likely witnesses in this matter.
Okay. Mr. Diaz, did you?
I mean, they're her children. I think that it would be, I guess, if everybody's concern here, well, part of everybody's concern is the best interest of the children. I can't imagine what it's like to say that she can't see the children and in effect telling the children that they can't see mom either. They're not named victims in the case. I don't see a basis for having a protective order that prevents them from having contact with their mother in any form or fashion. Either way, it's going to be supervised contact if there is contact. If they do come and see her, if she is in custody, someone's got to bring them. They're not of an age where they can come by themselves. So I think the state's concern about
talk over you. How old are the
11, 7, and 5.
Okay, thank you. Go on.
Yeah, I don't see where there's going to be supervised contact, any concern where there's going to be potential obstruction in any form or fashion. I think this is a heavy-handed tactic by the state to try to put undue pressure on her as it relates to this case.
Ms. Argyle, any response?
Your Honor, unfortunately, absent a mental health professional present during any interactions, a layperson is unlikely to be able to determine whether there's any duress or influence being made. And given the age of the children and the severity of the offense, it is concerning that additional trauma may arise if there is contact at this time.
Okay, and I guess
my response to that is if we're going to throw out mental health professionals, I don't know how a non-mental health professional can make that evaluation, that assessment the other way, if that makes sense.
So I guess my concern, Ms. Argyle, is maybe a little different than Mr. Diaz's, and that's the state submitted a protective order that alleges that the defendant represents a credible threat to the physical safety of the protected person. I don't know that that's what we have here. You've submitted a domestic violence protector, what is essentially a domestic violence protective order. So I guess, can you speak to the authority I have even to enter an order of this type where it's not alleged that they're victims?
Well, I would have to pull up the actual order, but if in effect, it doesn't matter. A non-domestic violence protective order can be entered under any violent felony, so the authority would be the same. As to the specific factual allegations, I think the PC statement really speaks to the specific concerns about safety, not just of the minor children, but of the community. And the obstruction allegations that have been made. So I think the PC statement speaks for itself as to the specific concerns. In these cases, in particular, we have concerns where we have had similar case scenarios where the minor children have later been attacked or murdered by the defendant as part of the ongoing process, and whether it's a mental health issue by the defendant or just simply a means to prevent the prosecution of the matter. That's the reason that there's a blanket allegation as to physical safety of the protected parties, because that is something that we have seen. We've seen it, unfortunately, where the party is released from custody and then those minor children become victims themselves later on. So that is the reason why that particular type of protective order is filed.
Okay,
And she's obviously not being released right now.
I understand. I think both council, what I'm inclined to do is sign the order today and allow you to bring this up in front of Judge Nelson. Sorry, this isn't Judge
It's
Nelson. Who
going
is
to be
this?
Judge Mao.
This is Judge Mao. So, Ms. Gledhill, for now, and until Judge Mao tells you something differently, ma'am, I am going to order that you have no contact with. So, ma'am, that means no in-person, no telephonic, no electronic contact. Ma'am, if you're released, you may not go near their residence, school. You may not have anyone else contact them on your behalf. And ma'am, while this order is in effect, you may not possess a weapon or ammunition. Ms. Gledhill, do you understand everything I just told you?
Yes.
All right, I'm going to sign this order right now. A copy will be served upon you at the jail. Ma'am, as I mentioned, this is a temporary order and it's subject to review by Judge Mao. Your attorney can certainly bring this up at the next hearing. But until that happens, ma'am, it is the court order that you not have contact with those individuals.
Okay.
The second thing, Ms. Gledhill, is that you are being held without bail. So I have to set this matter for what's called a detention hearing. At that hearing, your attorney will be present and can discuss your custody status with Judge Mao. The state's attorney will also be there and provide input. And then Judge Mao will decide if you need to remain in custody while this case moves forward. So Mr. Deus, I can either set this directly for a detention hearing or I can set it for a scheduling conference for the detention hearing. What's your preference?
Set it for scheduling for now, Your Honor.
Okay. How much time do you need for the scheduling conference?
Well, Judge Mao has a calendar on the 25th. Given my overall schedule, I'm asking the court to give me that date.
Okay, we can do it for a scheduling conference on the 25th. So Ms. Gledhill, your attorney is asking, so let me try that again. You have a right to a detention hearing within a certain short period of time. Your attorney is asking that I set this matter for a scheduling conference, which will then let you set a detention hearing. That way he has enough time to be fully prepared when it comes to the actual detention hearing. Are you okay with me setting it for a scheduling conference instead of an actual detention hearing?
Yes.
Okay, ma'am, that'll be the plan. I'll set this matter for a scheduling conference October 25th at 1 o'clock. That's this Friday. Ma'am, at that hearing, you can certainly set the detention hearing with your attorney. Just stay in contact with your lawyer, follow his instructions, and then you'll see Judge Mao on Friday. Okay, Ms. Gledhill?
All right. Thank you.
You're welcome, ma'am. Good luck to you.
Hey,
Thank
Jen,
you.
I'll be in to see you a little bit later this week.
All right. Thank you.
All right,
Thanks,
Mr.
Your Honor.
Deus, take care.